Hello everyone, welcome back to our channel Legal Nexus. In today's video, we're going to discuss a very important concept in law, ownership and possession. These two terms are often used together, but they are not the same. Ownership refers to the ultimate right or title a person has over a property, while possession means the physical control or custody of it. Understanding the difference between ownership and possession is essential as it is forms the foundation of property law and help us resolve disputes regarding rights and control over things. Ownership can be termed the legal right in the possession, use, and alienation of the property. It is essentially the most perfect relationship between a human being and property because its best authority in the owner to transfer or sell the property, concept, or even to alter its ownership is recognized by law. Thus, the law regards the exclusive control of the object unless transferred to some other person through the law. Essentials of ownership. Absolute right. Ownership confers total legal control over an asset, including the right to use or modify it. Transferability. He can transfer his ownership by selling, inheritance, or gift. Right to enjoy and dispose. The owner has very authority to use the asset, delight in its benefits, and dispose of it in whether way he wants to do. Indefinite duration. It is permanent unless voluntary transfer or legally revoked. Deprivation of others. Ownership gives a right to deprive other of interfering with the property except so authorized by the owner. Ownership without bodily presence. A person can own property even though he or she is not physically present over it. There are several kinds of ownership: corporeal and incorporeal ownership, sole ownership and duplicate ownership, trust and beneficial ownership, and legal and equitable ownership. We know there are several kinds of ownership. Let's dive into these ownerships in detailed manner. Corporeal and incorporeal ownership. Corporeal ownership refers to the ownership over a tangible and visible material things, for example, ownership of a car, pen, etc. Incorporeal ownership refers to the ownership over intangible and invisible material things. Example, ownership of goodwill, ownership of patent right, etc. Sole ownership and duplicate ownership means when ownership is vested in a single person, it is known as sole ownership. When ownership is vested in two or more persons at the same time, it is called duplicate ownership. Trust and beneficial ownership. Trust and beneficial ownership is an instance of duplicate ownership when one person responds confident in another's and transfer his property to the other for the benefit of a third party. The transaction is called trust. The person who transfers the property is called settler or author of the person to whom the property is transferred is called trustee. The person whose benefit the property is transferred is called beneficiary. In the case of trust, the trust property will be in the name of trustee and in the eye of the public. Trustee is the owner. However, in the eye of law, the beneficiary is the real owner. Thus, it becomes an instance of duplicate ownership. Legal and equitable ownership. In England, when owner of property agrees to sell his property to another, the buyer becomes equitable owner of the property and seller continues to be legal owner. Thus, it becomes an instance of duplicate ownership. In the case of Kochukunju Nair versus Koshi Alexander 1999, the Supreme Court observed that the right of ownership imports three essential rights, namely right to possession, right to enjoy, and right to dispose. If an owner is wrongly deprived of possession of his property, he has a right to be put in possession therefore. All the three essentials are satisfied in the case of co-owner of a land. The next topic of our session is possession. The word possession means physical custody or possession. Possession is a fact-based relationship whereby a person exercises actual dominion over property. The existence of this relationship is irrespective of whether the person in possession owns the property legally. Possession may or may not coincide with ownership. For instance, tenants possess property without owning it. Essential components of possession. Corporeal possession. The entitle of a person control over the property either directly or through another person. Animus possidendi. The person possessing must have the animus possidendi over the intent to control and exclude others. Possession without ownership. A person can have possession but not legal ownership. For example, rental or lease agreement acquire possession without ownership. Protected by law. Wrongful possession is also protected against the interference of third party but not against unlawful interference. Temporary or permanent. Possession may be temporary or develop into permanent possession. Elements of possession. In order to constitute possession, there should be two elements, animus possidendi and corpus possessions. Animus possidendi. In order to constitute possession, the most essential element is that the possessor should have intention to use a thing or for himself to exclusion of all others. Animus possidendi is the subjective element in possession. It refers to the intention of a person to have physical control of a thing to himself to the exclusion of all others. The animus possidendi is the consciousness intention of the individual to exclude other from the control of an object. Corpus possession is in order to constitute possession, mere animus possidendi is not sufficient. There should exist physical control of possessor in relation to the thing possessed. A person is said to be in possession of a thing when he has actual physical control over it, which would create a reasonable expectation that he will not be disturbed by others. Kinds of possession: immediate and mediate possession, and corporeal and incorporeal possession. Immediate and mediate possession. De facto and de jure possession. Immediate possession refers to the direct possession. If I go to the bazaar and buy a thing personally, it is a case of immediate possession. Here the relation between the possessor and the thing possessed is a direct one. Here the de jure and de facto possession are with the owner. In case of mediate possession, the owner of the thing possesses it through another. It is an indirect possession. If I send my servant to the bazaar to buy something and when he carries the thing which purchased for me, he possession is immediate but my possession is mediate. In such a case, I am the de jure possessor and my servant is the de facto possessor. Corporeal and incorporeal possession. Corporeal possession is the one possession of a material object such as card, books, etc. Incorporeal possession is the possession of anything other than material object. Thus, a person can possess immediate objects such as patent right, copyright, goodwill, etc. In the famous case of Mary vs. Green 1841, the plaintiff purchased a bureau at an auction and got possession of it. In a secret drawer, there was money belongs to the vendor. As the plaintiff had no animus in regard to that money when he took possession from the vendor, he did not acquire possession of it. The possession of the vendor was continuing in eye of law. As to money in secret drawer, the plaintiff who found the money and appropriated it was held to be liable for the offense of lunacy of theft. In conclusion, ownership and possession are closely related but distinct legal concepts. Ownership gives the legal right and full control over property, while possession shows actual control or custody of it. By understanding the difference, we can better analyze property rights, resolve disputes, and appreciate the importance of law in protecting both ownership and possession. Thank you for watching this video. If you found this video helpful, please don't forget to like, share, and subscribe.